Hello and welcome to this new opening session organized by the World Jurist Organization and located in Madrid and the city of Regensburg in Germany. The topic we're going to discuss is the rule of law as a universal principle. And this topic is really interesting and appealing to all of us because it reconnects us with the purpose and with the mission of the World Jurist Association, and particularly with the dinner hosted in London in 1957, where Sir Winston Churchill, the president of the American Bar Association at the time, Charles Ryan, and the Chief Justice of the United States Supreme Court, L. Warren, discussed and had a conversation about what could they do to promote peace and to guarantee freedom. Let's remember that on those years, talking at the end of the 50s, the Cold War was really going on, and the annihilation of the war was a possibility. So they decided to commence a global campaign for the promotion of the rule of law. And a few years later, the World Jurist Association started this biannual World Law Congress, the most significant and the most relevant conversation on governance, on constitution, on human rights, where leaders from all around the world gather each 2 years. Next World Law Congress will take place in the city of Barranquilla in Colombia. And this topic also reconnects us with events happened not so far ago as the 1950s. I'm talking about the last opening session hosted in Madrid, where Justice Stephen Breyer, justice from the United States Supreme Court, remind us that the rule of law is the best safeguard against tyranny, against arbitrariness, against dictatorship. So it's really an extraordinary topic, and I'm really thankful and grateful to have the opportunity to have speakers from 3 continents, from America, from Asia, and from Europe. Particularly, this opening session has been organized jointly with the International European Congress on Constitutional Comparative Law, led by Professor Rainer Arnold from the University of Regensburg, and also with the Konrad Adenauer organization. So, taking into account that the next Congress will take place in Colombia, now we're going to listen to a short video of President Duque. Although before, I wanted to inform all of you that the register for the World Law Congress is already open. So you can, either if you want to go to Barranquilla, to Colombia, on December 2 and 3 of this year, or either if you prefer to connect online, you can go to worldlawcongress.com, worldlawcongress.com. There you will find all the information to register and to participate on this global conversation about governance and about constitution and human rights. So let's hear now, please, to President Duque of Colombia.
I am very pleased to welcome you to the beginning of the 27th edition of the World Law Congress. More than 14 opening sessions that will conclude in our cherished Cartagena de Indias next year. It is an honor for all Colombians to host for the first time an edition of this true celebration of democracy. We received this designation as a recognition of our efforts in defending the rule of law as a guarantor of freedom, order, peace, and concord in our society, precisely when we celebrate the 30th anniversary of the 1991 Constitution, as well as the bicentenary of the promulgation of the Constitution of Cucuta. The world is facing challenging times for many reasons, including the COVID-19 pandemic and its huge socioeconomic consequences. So we must strive to amplify valuable dialogues, such as those promoted by the World Jurist Association, the World Law Foundation, and other sponsors of this very important Congress. That is why I salute the design of this innovative, ongoing format that will hold these online opening sessions with free access. It will be a great opportunity to promote the strengthening of the rule of law as the fertile soil to allow the growth of well-being, development, and freedom for our citizens. I invite the international legal community to participate actively in this democratic journey, which will be held throughout the next months in top cities like Washington, Miami, Mexico City, Buenos Aires, Hong Kong, and other cities around the globe. I wish you the very best during these months of knowledgeable building and sincerely welcome you to our country, when we will continue to work to build a better legal system and a better future for all based on the rule of law. Thank you so much.
Dear friend Diego Solana, as a representative of the World Law Association today, dear colleagues, dear participants to the seminar, ladies and gentlemen, I'm very grateful to the World Jurist Association and especially to its president, my disciple and friend Javier Cremades, for making possible an opening session of the World Law Congress to be held in Colombia, in Barranquilla, in December this year. My own Congress, the 23rd International Congress on European and Comparative Constitutional Law, will be held there as an autonomous part of the World Law Congress and is about to be organized together with the Konrad Adenauer Foundation. I'm very grateful for the willingness of the World Jurist Association and the Konrad Adenauer Foundation to support this Congress, my Congress is to say as well. Rule of law is the big topic of the World Jurist Association and also the topic of the World Congress. My international congress, which has already taken place in 2019 together with the World Jurist Association in Madrid, and which will take place next year together with the Constitutional Court of Georgia in Batumi, and then we hope in Ukraine, in Lviv, will focus on the rule of law. In connection with the COVID-19 crisis, that is, in connection with state situations of emergency. Further, the rule of law in connection with democracy, which can only be a real democracy if it wants to implement the rule of law. Furthermore, the rule of law confirmed and promoted by constitutional justice. And finally, also the topic of the rule of law as a universal value. These are the subjects of my Congress, which will associate it to the World Law Congress in December, planned for workshops. The rule of law as a universal value is also the special theme of our opening session today. And this special subject of our today's seminar also explains that today experts from different parts of the world are taking up this topic. Professor Landa from Peru, Professor Tanasescu from Romania, that means from Europe, Professor OTSU from Japan, from Tokyo, and the Advocate General at the Court of Justice of the European Union, Professor Tanchev, together with his Référendaire, Mr. Milan Kristof, who will present the joint contribution. Every constitution, provided it is a genuine constitution, is anthropocentric. That means oriented towards a human being in its content and its goal. In other words, the reference of a constitution to the human being is an anthropological axiom that recognizes the dignity of the human being as a basic value of the constitution. The dignity of human being means, as Immanuel Kant says, a value in itself that never allows the human being to be made an instrument for another goal. Human dignity is necessarily connected with freedom, also with political freedom, democracy. Dignity and freedom belong to all people who have to live as equals in a political community. This means restriction of freedom is necessary with regard to the rights of the other and for common public interests. The principle of proportionality is the appropriated means to show whether the restriction of freedom is necessary and individually tolerable, adequate, and therefore legitimized. What is essential is that freedom, which is by its nature linked to human dignity, is confirmed as a principle, and the restriction of freedom is regarded as the exception that must be legitimized. The principle of the rule of law transfers this order of fundamental values, dignity, freedom, and equality, into the sphere of action of state power, into the sphere of institutions. Institutions must realize these values. Public authorities are bound by all elements to the rule of law. They must observe the Constitution and the legal orders or laws made by Parliament or by the people. They must respect fundamental rights, and the legislator must enact clear and specific laws. These laws must not be retroactive. The protection of legitimate expectations must be guaranteed. Restrictions on freedom must be guided by the mentioned principle of proportionality. Judicial review must be effective and comprehensive. And the principle of separation of powers must be observed to safeguard freedom. Basically, we see that these core elements are present in all constitutional systems, even if they are not always observed, or euphemistically said, not fully observed in political reality. These principles of the rule of law also apply outside the state level. For example, within the framework of the European Union, a supranational community, but also in the relation of states with each other under international law. That is, they are universal. Let me repeat, the universality of the very essence of the rule of law is not called into question by the fact that it is not always fully respected. The following contributions will look at the principle of rule of law from the perspective of different countries and from the perspective of the European Union. To this end, now I start with Latin America, and I give the floor as the first speaker to Professor César Landa, who is Professor Principal at Pontificia Universidad Católica de Peru and of the Universidad Nacional Mayor de San Marcos in Lima. He is the ex-president of the Constitutional Court of Peru, and as I know, he is very much linked also to the European culture, which is to many respects a universal culture, because he had made for a longer time his studies in Germany. And I'm very happy that I'm often at his university, and I'm happy that he has declared ready to speak today to us, seeing the rule of law from political developments in his country, in Peru. So I give the floor to Professor Landa, please.
Good morning. Thank you very much by the invitation for this important seminar. And we have only 10 minutes, so I will begin immediately. because my speech is motivated by the interest in achieving a better understanding of the needs arising from the political transition from autocracy to democracy in Peru in the year 2000, in relation to the rule of law, which, although recognized in the Peruvian constitution, has shown its insufficiency to guarantee the balance and control between the powers of the state. In this regard, the constitution should not only encompass normative and constitutional foundation, but also be a reference to resolve social, political, and economic events that impact on our society, which represent a need and which are subject to constitutional protection, such as fundamental rights. However, in this occasion, the analysis of the rule of law will focus on the principle of separation of power. Democratic transition in Peru between volatility and the need of reform. One of the challenges for Peruvian society over the last 2 decades has been the constant struggle to consolidate a common democratic agenda, as well as the quest to broaden political representation in a country as unequal and fragmented. As a part of Peru's democratic history, there has been a constant political conflict between parliament and the executive, which has generated a massive detachment of the population from the representative institution. In the midst of the celebration of the bicentenary of Peru independence, it is notable that the political fragmentation within Peruvian society has been worsening, as on the one hand, a sector of society claims that the pandemic has shown the flaws of the current economic and political model of the 1993 Constitution. This is why it's merit profound transformation, such as the people dictating a new constitution, while another sector of the population points out in reality, it is not necessary to change it drastically. In this sense, the recurrent political crisis have highlighted the need to ask ourselves some key questions. What should political reform consist of? What should its specific contents be? Are we at a constituent moment of the democratic transition? This question allows us to offer some reflection on the 200th anniversary of the independence in Peru. In this way, the importance and the need to currently exercise the principle of check and balance of power as a structural constitutional principle between the government and the opposition in order to achieve governability in the constitutional state is evident. This principle arises for recognizing and seeking to integrate the competing interests that arise between the different institutions of power and is framed in the Constitution. However, with the recent political crisis of presidential vacancy, it has been observed that the use of political control by the legislative power has not been exercised in a reasonable and proportional manner, which has affected the balance of power, as presidential vacancy on ground of moral incapacity should only be used in various serious cases to prevent the tyranny of the majority from being imposed by the legislative power. Like any democratic constitution, the Peruvian constitution provides for a balance and check and balance between the executive and legislative branch. However, the new parliamentary majorities with the new president of Congress has been saying that with a 2/3 votes of the members of Congress, a presidential vacancy could be declared due to permanent moral incapacity. Without the figure of vacancy, without the typicity of the conduct reproachable to the president, nor the guarantee of the requirement of proven evidence, nor the protection of the right of defense to contradict the same, in addition to the lack of control of the parliament decision. Precisely is the war remembering that the Constitutional Court renounced to make an interpretation of the presidential vacancy due to permanent moral incapacity. Therefore, instead of pacifying and ordering the conflict of power, the majority of constitutional judges declined to rule of the matter, but they did not even really on the doctrine of not justiciable political issues. but rather on the procedural formalism of inadmissibility by subtraction of the matter. Peru is governed by a presidentialist model of government, attenuate as in most Latin American countries. It is not a classic presidential model because it has experienced throughout its history that embedding of parliamentary institution, which has resulted in a rather imperfect constitutional design that at certain political conjuncture has upset the balance of power between the executive and the legislature. On the one hand, the Congress of the Republic has the power to question or censure minister or to deny confidence to minister or the cabinet as well as to impeach the president, minister, among other high state authority. Thus, an individual minister of the Council of Ministers are obligated to resign if they are censured if their confidence is denied. For his part, the president of the Council of Ministers can request confidence if it is denied twice. The president of the Republic is constitutionally empowered to dissolve the Congress of the Republic and call for parliamentary election, except in the last year of mandate. In this context, in recent events in our country has shown us that it's necessary to rethink the role of our institution, as well as the role that citizens must play in a sort of right to democracy and governability. Following the political crisis, it has become too clear that our semi-presidential or attenuate presidential democratic model has been developing a strong tension between the parliamentary opposition and the president of the Republic. Regarding the interaction between the executive and the Congress, the Peruvian Constitutional Court has recalled in its jurisprudence that historically the model of government has been centered on an attenuate president system. However, historically, institution has been introduced in the Constitution that are typical of parliamentary regimes, which is in turn has been consolidated as principle of the relation between parliament and the executive and vice versa. This includes, in addition to the principle of separation of power proper, the principle of balance of power, the principle of cooperation, and the principle of democratic settlement. These four institutions are the foundation of the form of government that has been established in accordance with the Constitution. On the other hand, it's necessary to emphasize that the Constitution does not protect the views of the right according to the Article 103. In this way, the importance of guaranteeing the principle not only of the separation of power, but also of the control and balance of power as the foundation of the constitutional state of law, in which it is not possible to abuse the parliamentary majority to satisfy particular of political ends affecting democratic governance. In this midst of the political crisis and the social upsurge that led to massive protests in 2000, the last year, the structural change of our constitution through the convening of a constituent assembly came to the fore. Thus, a circular public opinion and citizens have expressed their intention to set aside the 1993 Constitution, but other side refused this change of the Constitution. The current situation is characterized by the absence of the debate following the restoration of democracy in Peru. Considering the chronic crisis of legitimacy and representativeness, the current ways of parliament, it would be an utopian ideal to consider that possible reform to the 1993 Constitution will respond to the will of the citizen. In conclusion, the affirmation of the rule of law, in particular the control and balance of power, has highlighted the need of the 1993 Constitution to be updated because its political and social economic model has been exhausted, as has become evident with the change of 4 presidents of the Republic in the last 5 years, which has affected governability and institutional stability in times of the serious health crisis of COVID-19. Finally, in this increasingly globalized world, although constitutional reform are national process based on popular sovereignty and respect for the national legal system, there is no doubt not only the economy, but also political are integrated into paradigms of the international order based on the depending of democracy, human rights, and the social market economy in accordance with the standard political and legal pluralism tolerance, respect for minority, and protection of vulnerable groups, as well as the control and balance of power as an expression of profound respect of the rule of law. Thank you very much.
I thank you very much, Professor Landa, for your excellent analysis of the problems resulting from political developments in Peru in the moment, and it culminates in the demand to update the constitution by reform, and separation of powers is endangered, and also balance of powers, and it is necessary that, let's say, the circumstances, the economic, political circumstances are favorable for the confirmation of the rule of law. And this will bring stability also, I suppose. And I think this was a very interesting analysis of what is going on now in a practical case, but important case in the framework of rule of law that's embedded in the history and in the political environment of a country. Yes, albeit the rule of law is always based on specific core elements which are universal, but we see that there are divergences, of course, in the understanding and in the realization of the rule of law in various countries. Thank you very much. And now I would like to give the floor to Professor Elena Simina Tanasescu. She is professor of constitutional law at the University of Bucharest in Romania, and is a judge at the Constitutional Court of Romania. She has been a consultant to the state president, and we know each other from the International Association of Constitutional Law since very long, and we both are also very much linked to the French culture by language, and but not only to the French. We see she speaks excellently English also, and yes. So, dear Simina, Elena, please take the floor.
Thank you very much, Professor Reiner, and thank you to the organizers for inviting me to talk on this webinar on the rule of law. My speech is not focused on an in-depth analysis of the entire case law of the Romanian Constitutional Court, or indeed on the concept of rule of law broadly speaking, but rather on some of the latest developments that have happened, particularly in the Eastern Europe over the past years, and which have been sometimes labeled as a constitutional decay. Now, when we talk about rule of law, we all know that rule of law is an abstract notion. It has been often analyzed from various angles, such as the elements, the characteristics that it has, but it has also been portrayed in an analytic manner in three different stages, I would say. In what has been labeled as a thin or formal conception of the rule of law, it has been defined as a set of formal values that compel the human conduct through the governance of rules. Those rules are enacted by the state, and they pertain to the formal aspects that legitimate power, making possible the compliance of human conduct with laws. By formally expressing power through laws, which can be enforced either benevolently or by the state power, laws acquire the capacity to subject human behavior in a more efficient way. However, according to this conception, the rule of law can be used as an instrument in order to better achieve political goals, irrespective of the content or substance of those goals. This political outcome has been perceived as a weakness of the formal theory, and it has been addressed by other scholars via a formal and procedural approach to the rule of law. In this conception, the rule of law refers not only to formal constraints objectively imposed on power and which make it legitimate, but it also refers to procedural commitments which imply a subjective attitude from the human subject. Namely, the human conduct is subjected to rules not only because laws are formally enacted in a valid manner, but also because the human subject is committing him or herself to those laws and may even adjust his or her conduct while being aware of those laws and being even able to challenge them. Furthermore, in what has been labeled as a thick or substantive approach of the concept of rule of law, the notion has been defined as not merely a set of formal and or procedural values, but also as an array of institutional arrangements stemming from normative commitments, many of them associated with liberal democracy. However, by tempering power, the rule of law still contributes to enhancing its legitimacy, although such an outcome is often relying on context. By tempering power, the rule of law creates the possibility for the human being to manifest itself in the context of power, and thus it allows the human conduct to become the main purpose of the rule of law. On the European continent, the standard of the rule of law has been developed in various instruments issued by the Council of Europe, and particularly by the European Commission for Democracy Through Law, also known as the Venice Commission. Within the European Union, it has made its appearance in 1992 in the preamble of the Treaty of Maastricht, and it was further developed in Article 6 of the Treaty of Amsterdam. Within the European Union, indeed, the concept acquired a new function once the phenomenon of rule of law backsliding or constitutional decay or democratic decay has been identified towards the beginning of the 2010s, based on developments noticed particularly in Hungary and Poland, but also to some extent in Romania between 2017-2019. Very relevant for our topic here are the judicial reforms that have been performed in each of these states, which have been perceived by the institutions as seeking to reduce the independence of the respective national judicial systems, and in some cases, even to jeopardize the independent functioning of constitutional courts. As of recently, the case law of the European Court of Justice with regard to the rule of law in this context of democratic decay narrows down the concept of rule of law to one of its elements, essentially to the principle of the independence of justice. This is exactly what has been challenged in those three countries that I've mentioned before. Judicial independence is important not only because it is considered a shield against external and internal influences, be they political, social, ideological, financial, etc., but also because it is considered a guarantee of the impartiality of justice with a view to the greater and general scope of justice, namely fidelity to law and not to state power or human will. This is the very essence of the rule of law beyond any other possible and even necessary elements or characteristics. The power of the courts relies as much in the rationality of the legal arguments which support their judicial decisions, as in the people's consent to obey the law. And that is something which stems from the substantive concept of the rule of law, from the thick concept that I mentioned before, and not from the formal or procedural one. Therefore, attacks on the independence of the judiciary, as they happened in the past in those three countries, are a serious threat to the rule of law. Now, I will not go into the details of each and every decision of the Romanian Constitutional Court, but allow me to draw a general conclusion that the thick approach, the one which emphasizes the tempering of power and the one which puts the human conduct in the center, in the focus of its attention, That approach has been also taken by the Romanian Constitutional Court, particularly over the past few years. It has been characteristic for the concept of rule of law that has been applied by the Romanian Constitutional Court. And I believe that this dimension, the independence of justice, it may be one of the characteristics that does bear a universal value within the broader concept of the rule of law. Thank you for your attention.
Thank you very much, Professor Simina Elena, for your very detailed and very interesting analysis on the one hand of the rule of law components, on the other hand also on let's say the reference to the actual jurisprudence in Romania. And I think that you referred also to the Council of Europe, the Venice Commission statements on the contents of rule of law, and statements which have much influence and impact on jurisdiction in the member states of the Council of Europe, so on the European region. And you highlighted indeed what is really very important, that the independence of justice is a pillar of rule of law. I think where the independence of justice is overthrown, the rule of law is not living. And this are the really the how to say the defenders of the law, and they must be independent. As you say, they have to look, they must be loyal to the law and not to the state power. That's right. Yes, thank you so much. And now let me greet Professor OTSU from Meiji University in Tokyo. Professor OTSU, who cannot be present because it's a difference of time, is yes, it's even more difficult as with Peru. Peru, it's very early, but in Japan, it's now about midnight. So he has sent us a video. Professor OTSU is a professor of constitutional law at the Meiji University of Tokyo. And since 2003, he has practiced as an advocate at the first bar of Tokyo and in the field of criminal procedure. So we see the phenomenon that often criminal lawyers are eminent constitutionalists, as I know from many constitutional courts in many countries. I thank him very much for being involved, and I would like, and I ask the World Jurist Association now to start with his video.
Dear colleague, good day. My name is Hiroshi OTSU, constitutionalist, professor at Meiji University, Tokyo. In this video lecture, I'll talk about the contemporary metamorphosis of the rule of law in Japan. Before the modern era, people lived under a variety of arbitrary rules and divided by each local authority. These prevented liberal economics and the guarantee of individual freedom generally. After the establishment of the modern unified constitutional states, not to mention the success of the citizens' democratic revolution, the principle of rule of law was therefore intended to remove such complication of feudal local powers in order to ensure national legal security. Thus, the Japanese government in the modern era, after the Meiji Restoration in 1868, a kind of revolution, though not a democratic one, adopted the purely formal principle of the rule of law of 19th century Prussia. This type of principle didn't include a constitutional value of guaranteeing fundamental rights or that of democracy. All laws, even but ones, must be observed. You know very much. After the defeat of the Second World War, Japan accepted this time the substantive principle of rule of law. The new Constitution of 1946 doesn't mention this principle explicitly, unlike the German Constitution of 1949, but it does prescribe the supremacy of fundamental human rights and freedoms, the monopolization of legislative power by the National Diet, whose members are all directly elected by the electorate, and the control of legality, including constitutionality, exercised by the judiciary over the exercise of all public powers. All public powers could no longer escape the control of the principle of the rule of law. However, there were still some exceptions in practice in Japan. Both the central and local governments often preferred a prior and informal negotiation to the formal decision with those concerned. They often used an administrative directive instead of the law or local regulation officially adopted by the deliberative assembly, the diet, or the local assembly. In the interest of the public authority obliged private actors to follow the administrative directive, which had no legal coercive force but de facto force, by threatening them with serious delay in the administrative procedure for authorizing their economic activities. Both the 1990s, such a method was quite successful due to the national mentality of the Japanese, a preference for coordination and spontaneous obedience to public interest rather than open protest and dispute resolution in the judiciary. This resulted in the great boom of the Japanese economy until the 1980s. Since the late 80s, Japan has been in a severe and long-lasting depression. However, the globalization of neoliberalism, accompanied by the progress of the effective rule of law, has increasingly dominated the whole world, including Japan, of course. Faced with the remarkable increase in the involvement of foreign capital in the Japanese market, the government has been forced to pass many new laws or legislative revisions through the Diet. For example, the Administrative Procedure Act, which aims to eliminate unfair delay and ensure transparency in the licensing process. But, on the other hand, such progress in the effective rule of law has caused many difficulties in the activities of local authority to maintain the quality of life of the inhabitants, including environmental protection. In fact, the majority of members of the Diet, always giving priority to economic development, failed to adjust the Town Planning Act in a way that was favorable to local authorities ambitious for innovation in the legal system. The existing legal regime didn't give small and medium-sized municipalities enough power to regulate the use of land, especially for the protection of the beautiful landscape. or the right to sunlight. In order to avoid derogation from the national legal regime, several ambitious municipalities used the administrative directive method. Until the mid-80s, it was quite successful in regulation due to the so-called Japanese mentality, as nobody went to court. But according to the economic globalization, the operating companies started the administrative litigation against such unofficial measure of the municipalities under the pressure of foreign capital, and they won in the lawsuit thanks to the judge aware of the effective rule of law. So we have to suffer a setback in the experimental policy of municipalities for the protection of the daily life of the inhabitants. However, ambitious local governments don't stop trying to deviate from the discipline imposed by the law, because local experimentation is necessary, which will replace the alternation of power, which is always very difficult at the national level in Japan. This is a polemic around the contemporary principle of rule of law. It means the reign of law in all public domains to guarantee fundamental rights. But which law and which fundamental right should be respected in the contemporary society whose common interests are very complex? Faced with this metamorphosis of the rule of law, a renowned French constitutionalist, Jacques Chevalier, proposed the new principle of the rule of law. According to him, the old rule of law was the monological rule of the national unitary power. Today, however, we are witnessing the emergence of a new rule of law produced by a dialogue between the national legislative power and the local level, as well as between the regulatory authority and the regulated parties. He said in French, l'état de droit dialogique. Thus, we have to accept a new competition between several normative powers, although it is different from the one before the modern era. Thank you for your attention.
Thank you, Professor OTSU. I say this to his video, but will say this to him.
Yes, I think we're having some technical issues. So I would suggest, if that's okay with you, if Milan Kristof can introduce his topic and his intervention from Luxembourg. Thank you very much.
Of course, it's a pleasure. It's an honor to be here. Actually, I would prefer to be there in person, but you know, what can you do? So I will present a joint contribution on my behalf and on behalf of Mr. Tanche, who is the Advocate General at the Court of Justice, and I'm a Référendaire, or a senior advisor in his cabinet. Obviously, the usual disclaimer applies. I'm speaking in my personal capacity, and we have a limited time, so I will try to be punctual. Please don't hesitate to interrupt me. This time obviously doesn't allow us to deal with all the case law of the Court of Justice on rule of law, which is becoming quite a significant body of case law. And Simina has mentioned that the Court of Justice has been busy as well. But I have made a selection of a few interesting and recent cases, which I think are relevant, and I think it will allow the viewers to catch a glimpse of the case law of the court and how the court approaches these issues, and also what the court has been grappling with. And it will link also with Simina said and Rainer, that, one of the most important elements is the independence and impartiality of justice. And one of the cases in particular two of the cases will deal with the National Councils of Judiciary. So it will be interesting because, let's say, the results are different in those two cases. In one of them, it was ruled that there are risks as to the rule of law and independence of the judiciary. And in the other case, the court ruled that there was let's say, no risk to the independence. So the first case I would like to talk about is called AB versus Krajowa Rada Sadownictwa. So that's in Polish, the National Council of the Judiciary. It's a case C82418, and it was one of Advocate General Tanchev's cases. And in the judgment, the Court of Justice in March this year ruled that the successive amendments to the Polish law on the National Council of the Judiciary have the effect of removing effective judicial review of that council's decisions proposing to the president of the Republic candidates for the office of Judge of the Supreme Court are liable to infringe EU law. So that's interesting because, and that I think Rainer also mentioned it, that effective judicial review is obviously very important. And in here, the national provisions have removed the possibility to have effective judicial review of the decisions of the National Council of the Judiciary. And so the Court of Justice examined that and ruled that under EU law, that is liable to infringe EU law. And if an infringement is proved, then the national court that referred the preliminary question can use the primacy of EU law to disapply such amendments. First of all, the court in that case pointed out that the Polish Supreme Court is a court which may be called upon to rule on EU law. So because of that, because it may rule on the application or interpretation of EU law, it falls within the scope of Article 19, paragraph 1 of the Treaty on the European Union. And that's why the independence and impartiality of this court, of the Polish Supreme Court, is also very important and essential from the point of view of the EU law, not just, let's say, not national law, but also the EU law it's very important that it's independent, the Supreme Court. And this case dealt with the selection or appointment procedure of judges to the Polish Supreme Court. The court also in that case states that the Article 267 of the Treaty on the Functioning of the European Union, which is on the preliminary reference procedure, and the principle of sincere cooperation preclude legislative amendments such as those in this case, where the specific effects of those amendments prevented the Court of Justice from ruling on questions referred for a preliminary ruling. And that's also interesting, I think, for our webinar, is to see that this also means that the national judge must be independent and have the right to refer questions to the Court of Justice where it has doubts, let's say, about certain national provisions, because in that case there was a risk that the national judge would not be able to ask the Court of Justice for interpretation of EU law, and that also obviously has an impact on the independence of the judiciary. The Court of Justice also recognized that in principle a council for the judiciary is an important and can constitute a safeguard for judicial independence. However, what is important is that such a council must be independent itself. And so the council for the judiciary must be independent from the legislature and also from the executive. And in this case, in the Polish context, there were already controversies relating to the independence of this council. And that's why the Court of Justice said that a fortiori in such a situation, the existence of an effective remedy against the resolution of such a council is important. So the court also rules in its judgment that the method for the appointment of judges can have a key impact on judicial independence and also on the public perception of independence. And so that's why the court clarified that the substantive and procedural rules governing judicial appointments in national systems are very important, and they must prevent reasonable doubts as to the imperviousness of the judges concerned to external factors and to their neutrality as judges. Then the second case also deals with the National Council of the Judiciary, this time not in a Polish but in a Maltese context. Its case is called Republika versus Il Prim Ministru, the number is C89619. The Advocate General was Mr. Hogan, and in the judgment in April this year, the Court of Justice ruled the national provisions of a member state which confer on the Prime Minister a decisive power in the appointment of members of the judiciary, while also providing the involvement of an independent body responsible for assessing the candidates and providing an opinion to the Prime Minister, such as is the National Council for the Judiciary, are not contrary to EU law. So in the Maltese context, the Court of Justice examined the arguments and all the elements and ruled that it does not appear that the provisions in the Maltese context could lead to the members of the judiciary selected in this procedure as not being seen to be independent or impartial, and therefore there was no risk that it would undermine the trust which justice in a democratic society must inspire in individuals. The court ruled that the Article 19 of the Treaty on the European Union, in particular, so is relevant in this context. It was not really applying directly the Charter of Fundamental Rights. But what is important also in this case is that the Court of Justice pointed out that under Article 49 of the Treaty on the European Union, which deals about what criteria, let's say, there are for countries that would like to become a member of the EU. And so the court ruled that because of what is in this article in the treaty, it means that the EU is composed of member states that have voluntarily and freely acceded to the EU, and they committed themselves to comply with certain common values, which are referred in particular in Article 2 of the Treaty on the EU. And as we are talking here, the rule of law is one of them. And so if these countries have committed to abide and promote these values, they cannot, after joining the EU, then amend their legislation so as to, let's say, bring about a reduction in the protection of the value of rule of law. So, the Court of Justice ruled that those that are already members must make sure that they maintain the levels of the protection of values such as the rule of law, and they cannot introduce legislation which would deteriorate those standards once they are members of the EU. So that also the court ruled that they must refrain from rules which would undermine the independence of the judiciary. Then the third case was already mentioned indirectly by Simina. It's the judgment on the Romanian Judges Forum. It was a 6 request for a preliminary ruling from Romanian courts. One of the, let's say, the first case is 8319. And the Advocate General was Mr. Bobek. And in May this year, the Court of Justice ruled on series of reforms in Romania in the areas of judicial organization, on the disciplinary regime applicable to judges, on the financial liability of the state and personal liability of judges. And first of all, as regards interim appointments to management positions within the Judicial Inspectorate, the Court of Justice ruled that in this case, once it examined all the arguments, there were actually doubts that the national legislation in question could serve, so it could actually, what was at issue was that there were rules, let's say, for the appointment of members to the management positions of the body responsible for conducting disciplinary investigations. And here the court said that if there are rules such as these in examining the case that would even temporarily allow the government of the member states to make appointments to these positions by disregarding the ordinary appointment procedure, then the court said that this could lead to doubts as under the independence and rule of law. Then in relation to the creation of a special prosecution section with exclusive competencies for offenses committed by judges, the court clarified that such legislation, in order to be compatible with EU law, must be justified by objective and just verifiable requirements relating to the sound administration of justice, and must ensure that that section cannot be used as an instrument of political control. Basically, this permeates the argumentation of the court, is to make sure that special prosecution sections, let's say, they mustn't be used as a weapon of pressuring or intimidating judges. And the court has given the national courts, which made these references, some interpretation of EU law. Finally, on the state's financial liability and the personal liability of judges for a judicial error, the court said that the legislation must be clear and precise, and it must be necessary for ensuring that neither the investigation nor the action for indemnity can be seen as to be converted also as an instrument of pressure and judicial activity. And the court also points out that these kind of rules must not be used and in order to have a chilling effect on judges in the performance of their duties, and so must be used objectively and impartially. I think I have used up my time, but I hope this little glimpse of the court's case law was useful, and thank you for your attention.
Sorry, yes, I was interrupted somehow in the internet connection, and so I could not yet present Milan, but I will do this now. First, many thanks for this interesting analysis. It's very important to have to know the perspective of the European Union Court of Justice, which has high impact on all the member states. And well, Mr. Milan Kristof is Référendaire. This means scientific and collaborator of Advocate General Yevgeny Tanchev. Mr. Kristof was Référendaire also to the former Mr. Mazak from Slovenia. And I thank him very much that he has taken over this task to speak. But it is a joint message, so to say, a joint study of Milan Kristof and of Yevgeny Tanchev. And some words to Yevgeny Tanchev, who is I've been working with him since long time, a very good friend, but I must say really his office is now expiring as an Advocate General in October, and he has been is a professor at University of Sofia, and he has been the president of the Constitutional Court of Bulgaria. He has been vice president of the Venice Commission of the Council of Europe, and since 2016 he has been an Advocate General of the European Union, of the European Court of Justice in Luxembourg. I think so. He has contributed during his professional life with great efforts and with intensity and with success to the spreading out the idea of the rule of law. And this is very important. And I would like to thank him for this also in this occasion, and also to give him my and our very cordial greetings, and connected with the hope that he will have I don't know, but also a very good and the rule of law oriented and promoting professional activity after his retirement in Luxembourg. So thank you indeed. We see these interesting cases. Rule of law is also the heart of European Union, Article 2 of the Treaty of European Union, and concretized by the Fundamental Rights Charter. And yes, all the elements of rule of law have appeared also on the level of the European Union, and we see the very important practical use of these elements. And even in the 1960s and 70s, by the European Court of Justice of the European Economic Community at that time, has developed from as general principles the aspects of rule of law, besides the development of unwritten fundamental rights deduced from the member states. And this has been confirmed now, and we see that the preamble of the European Union Fundamental Rights Charter refers expressly to the rule of law. And we see also that the influence of the European Convention of Human Rights, and behind this convention, of course, of the very important activity of the Venice Commission, of the Council of Europe as such, and of the Venice Commission formulating the aspects of rule of law. And all this is a developing standard, a European standard, but not only a European standard of the rule of law aspects. And I think today we have had got the insight that the rule of law is appreciated all over the world, and it is embedded, of course, in a national system, in a national, on the national level, in a country's system, in the country's history, as in Japan, or in the country's politics, as we see in Peru. And I think my idea was that the basic constitutionalism elements are universal, really, because they are derived from human being. This human being has got her emancipation also juridically, and of course human being was existing in human dignity and freedom. This was from the beginning on, but the perception is different, has developed during history, and is also maybe to some extent different perception, means how this is understood by political power, or even also by justice in the countries of the world. But the core element has been from the beginning on, and now has been more recognized today as a core element on these what is essential for human being. And yes, and this influences the modalities of contact, as it was underlined by Professor Elena Simina. And so, of course, it's an highly important means and criterion for comparison of law. This is clear. But as I have chosen this title for our seminar, means as a universal principle, I was sure that, I'm sure, perhaps it is contested, but I think that the core elements are universal, and they are the basic elements of an authentic constitution. And there something what is called constitution, but which would not guarantee these elements, is maybe a statute for organization, but not an authentic constitution. And okay, and I think this is important to have the discussion, because there is a difference between what I would name normative reality, which exists, but the perception is how politics, how jurisprudence in this country or wherever, how people, how also the, let's say, the political culture perceives these elements. This can be different, but it is, I think, our task to reflect on this and to go on. And more, I think we can also state and consider that the impact of the international and supranational level is growing. The rule of law, of course, is in its origin something what belongs to a state. But as the notion, the concept of rule of law has been enlarged from a formal one, yes, which is more state-like, to a substantive one, which includes in particular the human rights and the fundamental rights. So the international level is also now penetrated in a positive sense by the rule of law. And at this point, I always must repeat that the existence of rule of law in its true form is not endangered by the fact that, unfortunately, the rule of law is often not fully observed, and in sometimes may be seriously not observed. But now, so I want to say that the perspective of the Council of Europe, the perspective of the European Court of Justice, and the perspective of a comparative or of comparison is highly important to know, or to more and more to get familiar to what is the core element, or what are the core elements of the rule of law. Now, I would ask you if you want, yes, or please give your comments or ask questions. Now I give back first my floor to Diego Solana. I think he can decide whether we can go into a discussion or not, or what do you think?
Well, it's up to the speakers. We have still 10 minutes, so
Yeah.
any final remarks from Romania, Luxembourg,
It would be fine if
Japan, it would be great.
everybody could do a conclusive remark or even ask a question to one of the panelists. And so please go on, maybe in the order of presentation. So César, please, what would you say?
Thank you very much. It was very interesting to hear different points of view about the rule of law, because I think the core of the rule of law is avoid the concentration of the power in one power or branch. In this way, for example, for me it was interesting to hear the exposition of the colleague from Japan, because the main problem of the rule of law is the decentralization of the power, not the concentration of the power. In the Peruvian case, it was the government opposition. There has not been a balance in the democracy using the instrument of the check and balance. And this balance create ungovernability. In the European cases and the experience that I heard, is very important, the role of the judicial power to control the excess of the governments. But I think that there is, in this way, in this time, illiberal democracy, not only in Poland, in Hungary, but also in Brazil, in Nicaragua, or Salvador, Venezuela, in Asia also. And I think the rule of law has to find the core of the conflict that's put in danger the human rights, the independence, the judicial power, but also the balance between the political power. And I think that democracy must to exist with the support of rights, but there is no rights without democracy. So it's only a political and understanding of the democracy in values of pluralism and tolerance between the majority in the power and the minority that is on the other side. It's my words. Thank you.
Thank you very much. Simina, please, can I give you the floor?
Thank you so much. And just to continue the idea, Professor César Landa, indeed, in my presentation, I have spoken mainly and almost only as a complement to the presentation made by Milan Kristof on the independence of justice, because this have been the last development in roughly Eastern Europe, but also in Malta, as he has very clearly pointed out. But indeed, we have not to forget, and we have to remember all the time that rule of law means not only separation of powers, not only independence of justice. It doesn't refer only to this institutional array, but it refers mainly and mostly, as I was saying, in the fifth conception on the rule of law, on the human being, on the dignity of the human being, as you were saying previously, Rainer, and basically on the fundamental rights of the human being. As long as we have this as a main focus, I think we will manage even to overcome the inherent tensions that exist, at least theoretically, between rule of law and democracy. Thank you very much.
Thank you. Now, Professor OTSU cannot be interviewed, but so I would like to give the floor to Milan Kristof. Is interrupted. Milan,
yes.
Now please take the floor.
Yes, thank you, Rainer. So maybe just a few remarks on what has been said. Indeed, as you were saying, and also Simina, there is obviously what is very important is the comparative approach. And actually, many of you will know that the Court of Justice regularly refers in its case law to the case law of the Strasbourg Court, the Court of Human Rights, and vice versa. The Strasbourg Court also refers in its case law to the case law of the Court of Justice. So that's also, I think, good, that there is this dialogue, the judicial dialogue between, let's say, these two courts, and which I think has been very beneficial to everyone. Furthermore, I also wanted to say that yes, the cases we have mentioned are from Eastern Europe, but I think the rule of law has to be defended everywhere. And maybe you have seen after Brexit in the UK, when there was this ruling, or one of the rulings by a UK court, then the Supreme Court, then on the first page, those judges were depicted and with big letters as enemies of the people. So I think, the rule of law has to be defended everywhere, not just in Eastern Europe. And I think events like this one are definitely very useful, and it was a pleasure to participate. Thank you.
Thank you very much. Yes, from my side, I would like to thank really very much to all the panelists, and I hope that we can meet again, and in particular that we can meet in Colombia on December 2 and 3. And then, yes, I have already spoken about the planned workshops I have in my Congress, but we are a functional unit, of course, with the World Law Congress and incorporated, so with a big brother, so to say. And now we would really like also to, it will be a hybrid Congress, but we would very much like to be there in presence. And last week, as Simina was also in our international roundtable in Aix-en-Provence, and for me it was the first time after the pandemic to go, after 1.5 years, to go by plane. And I must say that it is really a surplus. It is something different to make it online and to be in touch in presence. So both is good, but in presence is better. And so I want to encourage you to come, and it would be great. But I think also, and I said this initially, I want to repeat it very much to the World Law Association, to Javier Cremades and to Diego Solana, to Yeki, to all the participants and collaborators for having encouraged and having organized this seminar of today. And also they are organizing, and this will be a great event, of course, high level and great and large event in Colombia. I wish all the best for organization, then best success, and I am very happy for me personally. So I look forward really with great expectation and joy to join you in Colombia. So I give back the floor to Diego, and thank you.
Thank you very much, Rainer. Thank you, first of all panelists to be here. Muchas gracias a todos por participar y por permitirnos entender un poco mejor qué es el Estado de Derecho, qué es el Rule of Law. Creo que nos hemos llevado una impresión muy profunda de diferentes países: Rumanía, Perú, Luxemburgo, Regensburg, Japón. Espero que podamos continuar esta conversación en Barranquilla los días 2 y 3 de diciembre en la distinción que hacemos desde la voz global del derecho, desde la World Jurist Association, a esta democracia, a este país que ha tenido tantos retos como es Colombia, pero que los ha ido superando con muy buena nota. Recuerdo a todos los asistentes que ya está abierto el registro para bien registrarse de forma presencial o bien registrarse a través de videoconferencia en la página web worldlawcongress.com. Muchísimas gracias a todos. Thank you very much and all the best, and I hope to see you in Barranquilla, in Colombia. And it will be also my first time to leave the country, to leave Spain, and to board in an airplane. I'm really looking forward to see you all there in Barranquilla in December. All the best.
All the best. Thank you.
Much.
Good night. Goodbye.
Thank you. Bye-bye.
Thank you.
Bye. Bye. Adios.
Adios. Adios.